The program, and as always, we value your feedback on some of the topics we'll be talking about during the course of this broadcast. 22422 is our SMS line, and we can use the hashtag CitizenExtra on social media to allow us to track that conversation. Let me get straight into the big interview this morning. The Law Society of Kenya President Allen Waiyaki joins me in studio. Welcome to the program.
Thanks, Mara.
Thank you for finding time to be here with us. It's been a few months in office, but off air, you told me you believe you've accomplished a lot. Maybe we can start there.
Thanks. Well, we were sworn in on the 24th of March, and effectively we hit the ground running from April. So it's just been about barely 3-4 months.
Okay.
And what we decided as a council was to set a target of 100 days magic achievement. What can we do within 100 days? And what we set out to identify was basically what is the core value of the Law Society. Number one, under Section 4 of the Law Society of Kenya Act, we are supposed to assist the government and the courts in the issue of administration of justice and the rule of law, upholding the Constitution, which we have. Number two,
do you have any specifics?
Yes, we have. Let's start with public interest litigation. The minute we came to office, one of the first public interest litigations that we instituted was one against the NHIF, when they outlawed affidavits by lawyers, which we found to be unconstitutional, because it bars access to justice to ordinary wananchi. Basically, what they're saying is that don't get an affidavit from an advocate, but now you must go to a magistrate to get an affidavit. Now, how many Kenyans would now wait for hours to go to a magistrate to get that affidavit? Yet if you went to a lawyer, you could just have it done in half an hour. That is one of the things. We went to court and we succeeded and got a stay. So the matter is pending in court. Number two was the issue of the digitization of the lands office. Now, of course, you know that we were vilified, that we were against digitization, which is unfortunately not correct. We support digitization. Now, what had happened was that the lands office carried out the program without public participation, which is a
although they said they did carry out, and we did see you having several meetings with them.
Yes, that was prior to that. Now, when we went to court and we pointed out the deficiencies in the system, because the system had not been tried and tested, it didn't have proper legal framework. Because what had happened was the guidelines were formed before the land regulations were passed by Parliament. So we said, look, we respect that under Regulation 9 of the land regulations, which were pending in Parliament at the time, does entail the provision of this, the creation of these guidelines. Why don't we wait, set up a task force, and come up with proper guidelines? And I'm happy to say that once we went to court, we sat down with the CS and her team, and we agreed on the way forward. We entered into a consent, and anytime now, I understand the task force is going to be gazetted, where LSK is also going to have 2 of its members be part of the larger task force to come up with proper guidelines. And the advantage of digitization is, one, we hope it will stem out corruption, fraud titles. 2, it will improve the delivery of services to the ordinary wananchi, such that under the regulations, there are actually specific guidelines and timelines within which certain transactions are supposed to be completed. Within 10 days, for example, you could have a charge registered, which is a marked improvement from the months of delay. So we really support that. The problem is misinformation. When members think that lawyers are going to court over something, interrogate first. And I always tell people, I don't jump to conclusions. I'm not the kind of president of Law Society to quickly yap like a mad rabid dog simply because something has occurred. I need to get the facts, I need to consult, and once we've come to the right conclusion, then we inform the public of what the true position is.
Would you then say that is your response to people who say that as a president you have been rather quiet? When you look at the precedent set by those who were in office before you, they were constantly in the media, or constantly engaging somewhere out there publicly, but for you, it seemed quite the opposite. Well,
you see, the thing is, my president is more like a volcano. The power is underground. What we're actually doing will be seen. And I'll tell you how. One, going on the media all the time, what do you achieve by just talking all the time and there's no action? This is a council that actually acts. One of the ways we've actually revitalized as a law society is to re-energize the committees that advise the council, which in turn now propagates the recommendations. We have set up a tax law committee. We're already sending today to Parliament recommendations on the finance bill. We have set up a public interest litigation committee which is quite vibrant, and you'll see a lot of public interest litigation going on. Already we've got about 5 cases in court. Recently, in fact, you said, what have we done? We went and challenged the executive order that had lumped independent commissions under the Attorney General. And we said, you can't do that because that's unconstitutional. And we got a stay, by the way. So far, we've been successful with a few public interest litigations we've filed so far.
And I think, and it's very interesting that you've come for this discussion, because that is good information that's coming to light. So why is the information then not getting out to the public? Because, and I did talk to a few people before this interview, and a lot of them were of the opinion that, for example, the fight against corruption.
Yes.
It's been the big talking point for the last 2 months.
Correct.
One would have thought that Allen Waiyaki Gishohi would have been sort of at the forefront in all this, talking about whether giving guidance on how pre-trial, for example, let's talk about NYS.
Yes.
Pre-trial conference has been dragging on since May. You know, one would look to the LSK to give direction, or in a sense to give its voice, give its stand.
Well, that's a good point. But you forget one thing. Aren't we advocates also representing the accused? Aren't we also advocates who are prosecuting through the state councils, through the DPP? Those are all members of the LSK, if you look at it that way. Secondly, when matters are in court, the issue of just sub judice. Why would we comment on matters that are pending? For example, the issue of bail. We've even made comments, but they're not publicized, that bail is a constitutional right. No one should be deprived of bail. All you have to do is for the court to set the standards or requirements for bail, and you'll be granted. So you'll have to appreciate the Kenya today from the Kenya. People think that the Law Society should be the Law Society of 20 years ago when they're single-party state. Now we've got a very vibrant independent position of the DPP. You've seen he's done his work. You've seen that lawyers have also come to the forefront to defend the accused persons, because we always say, and we've made it time and time again, that a person is presumed innocent until proven guilty. The system works. Yes, there have been delays in processing of bails. Recently, in fact, just this week, we even wrote a letter and said it is wrong and improper for an accused person to be arrested on a Friday evening. So you hold that opinion? I have written to the DPP, to the AG, to anti-corruption, to the IG, and I've said it is not right for an ordinary Kenyan. If you've done your investigations, why are you waiting until the last minute on a Friday, arrest and incarcerate that person over the weekend, because you know very well that no courts operate over the weekend? That is causing mental anguish. In our view, that is not right. That's basically unconstitutional. Because what are you trying to do? Are you trying to punish someone who's not even been proved guilty? We have written on that. We have raised those concerns. We have had meetings with the DPP, and those concerns have also been raised. So I don't know whether we are supposed to go out to the top of the hill and boast and thump our chests that this is what we've done. But the thing is, we are actually doing a lot of stuff going on. What would you say has been the LSK's role so far in this particular fight against corruption? Now, let's start with our own domestics. One of the things that, of course, that is quite profound in the common theme is that money laundering seems to be the common thread, isn't it? Because many of these corrupt or alleged corrupt persons come through lawyers to buy properties. And some lawyers have even been accused of being the ones who hold money on their behalf. Yeah, that's true. Those accusations out there. So now, to protect the members of the public, to protect our profession, we have undertaken an exercise of coming up with money laundering guidelines. And these guidelines are actually best practices internationally. We are going to adopt what is the best practice. Like for in England, for instance, there's got money laundering guidelines that run to over 100 pages. So as we speak, in fact, our committee mandated to do with that has started the exercise. We're already partnering with some of the donors to assist us in the process. So going forward in the next couple of months, we will have those guidelines in place so that we will ensure that lawyers are also not victims. Because you know, at times you could do something innocently thinking that that there's no crime alleged. A client has come over, said, I want to purchase property, and we have to interrogate. Where did you get the sources of money? That's what the anti-money laundering legislation is all about. So we want to have those guidelines to protect our members and to protect members of the public. What would you say about a situation where a company secretary who is a lawyer signs some documents on behalf of the company, and then on the day when they're all picked up on that Friday, that company secretary also gets picked up as well? Now, in fact, that's one issue that of course, has been raised and caused a lot of hue and cry amongst our members. And one of the things that, of course, we have made it very clear is that one of the things I even raised in that letter I wrote this week is that it is not right for you to pick a lawyer who, in the course of the duty, makes a free, fair opinion based on the law. For example, let me give you an example. You're involved in a conveyancing transaction, and you've carried out proper due diligence at the lands office and the company's registry. You have been given official documents by the government saying that so-and-so owns this property, or this property has the following shareholders.
The purchase of a property on behalf of your
exactly.
client.
So based on that information, we advise our client accordingly that this is okay. It's a clean transaction. Let's proceed. Turns out a few years later that those documents were actually fraudulently prepared by certain government officials. So that is where we have a great cause of concern, because how can we be blamed if the situation is such that those documents were manufactured from the source? We also have instances where we say, I'm not saying that everyone is clean. We're not as white as cotton. There are, of course, instances of some of us who have fallen by the wayside and assisted in that. Now, all you're saying is let the due process take its course. If there's going to be an investigation against any Kenyan, whether a lawyer or an ordinary citizen, carry out the investigations properly. Because one of the worrying trends is this. You find someone who's arrested, taken to court, denied bail on the basis that, oh, we're still carrying out investigations. I mean, that is ridiculous. That means you have not done a proper job. And that's why the judiciary should not be blamed if such cases go to court and persons are acquitted for lack of evidence or lack of proper investigation
was not done. On the flip side, and I'm talking about lawyers who voted you in because you are their president.
Yes.
Most, or can I say some of them, are perceived as a deterrent to justice in this country, or to access to justice, especially defense counsel, who are seen to be defending alleged criminals at the expense of the common Mwananchi because of their mastery of the law, and they thus understand how to go around it. For example, I have heard from some that in a matter of corruption, as long as you can delay the start of that case, get the media uninterested in it, then you have a much better chance later on of getting your client off scot-free. You put things in place, anything that you can come up with as defense counsel to delay the matter, have it pushed to tomorrow or the day after, then you're fine. Does that worry you? Is that a concern? Have you heard anything?
Yes, that has been a concern, by the way. In fact, over the couple of years, that has been one of the major concerns. And one of the things I even suggested is, why can't we have even a sort of timesheet showing when this criminal case started, when was it concluded, what are the delays? I'll give an example, like one matter that we lawyers are very keen on. Our late brother Willie Kimani, who was murdered, and the matter is pending in court. I can't go into details, but one of the concerns was the delays by the defense. Every time the case is ready for hearing, it is adjourned for one reason or another, usually because someone is sick or for any other reason. But there is a system in place that the Chief Justice had put, I believe retired Justice Mutunga had put in place, and it's also been implemented by Honorable Justice Maraga, that such cases are supposed to be heard and handled expeditiously. So measures have been put in place. And we expect that under the new fight against corruption, these cases, which have elicited a lot of public interest, should be determined expeditiously. Because remember one thing, under Article 50 of the Constitution, cases are supposed to be heard without unreasonable delay. So it's already there in the Constitution. It's just a matter of the implementation. Of course, at times there could be delays because, one, of the nature of the witnesses. There could be so many witnesses. There could be so many defense counsels. So you have to appreciate that. So it's not right to come up with a blanket condemnation saying that they're deliberate acts. There are times, of course, that, and I've repeated this several times, that an accused challenges the criminal process, and that is a constitutional right. So you have to let the criminal process go through. You may end up going to the Court of Appeal, and then the Court of Appeal sends you back. So it's just the normal practice. So we have to appreciate that the law has to follow its course.
The law has to follow its course.
Exactly.
Are the days of an LSK that had an activist tinge to it, are they gone?
Well, I don't understand what you mean by activists, because if you say we are activists by upholding the Constitution and upholding the rule of law, then we are guilty as charged.
Okay.
We will make it very clear. Let's make it very clear. We will be involved in a lot of public interest litigation going forward. Look at, for example, the Solai Dam. The LSK has been enjoined as a party, and we want justice for the people there. Right now, there are a few public interest litigation cases we have lined up which I cannot disclose. But you will see those happening within the next 1 month. We're not doing it for the sake of doing that. We're only simply doing it for the sake of upholding the constitutional right of the ordinary mwananchi. So quite a number of these things affect the rule of law, affect the constitution, and there is a lot going on. I mean, like recently when we went to court when Justice Osarme was ordered to go to Parliament, the LSK went to court and said, look, if you've been elected by your judges, surely you cannot undergo another vetting process. It's the same way, for example, if our JSC representative who is told you have to go to Parliament to undergo vetting, yet you have been popularly elected by the members. It is not right. What will happen then if Parliament says you're not fit, and then you go back and you're elected again? It's a vicious cycle. So those are some of the things that that we've looked into, and we've succeeded in the recent past. I
want to get your thoughts on, they call him the people's litigator, Okiya Omtata.
Yes.
You were recently in the paper.
Yes.
I don't know if you were misquoted, because sometimes I've had guests who say later on that they were misquoted.
Yes.
That you said that he's taking away work from some lawyers or something of the sort. Maybe I can give you a chance just to clarify what you were saying.
In fact, I was misquoted, and I made it very clear. And I made it very clear that under Article 22 of the Constitution, every person in the country is entitled to institute public interest litigation to safeguard and uphold the fundamental rights. Okiya Omtata is perfectly entitled to do so. What I clarified was this. What we are concerned as lawyers is those proxy fights where, for example, let's say you're employed in a parastatal, then you're sacked. Now, who would be the proper disputant? It would be you. Then you go hire someone like Okiya or someone else to come and fight your put your fight. That's where our concern was. Yes, that's what's been happening, by the way.
You have proof?
Yes, I have proof, and in fact, I can even this morning I called one of the advocates involved who was defending parastatals, and it's been happening. So what happens is, what you're saying, under the Constitution, one of the exceptions is this: you can fight on behalf of someone who is incapable of fighting. But these are not persons who are incapable of fighting. Take, for example, the recent case in Mombasa of the MD of Kenya Ports. Someone went to court to challenge her suspension. But who is the victim? She is the victim, isn't it?
But doesn't any other Kenyan then have the right if they feel aggrieved on behalf of someone?
Yeah, but you see, that is a personal right. It arises out of your nature of employment. That's where we have a problem. But we applaud Okiya Omtata for his initiative on so many cases. In fact, one time I had a meeting with the judges at the Court of Appeal, and they even recognized that there's one case he had gone there and stopped a corrupt payout of almost 60 million shillings. So we applaud him. By the way, in fact, we are not against anyone going to file a constitutional petition. That's why I was saying I was misquoted. It's only those proxy fights that we are concerned with.
Are proxy fights illegal?
Now, they said the problem with proxy fights is this, yeah? And this is, now to look at it is this. It's the whole issue of locus standi. Do you have the right to fight for someone who's capable of instituting that? Why is it done? It's because you will then reveal confidential information from maybe the government or parastatals. And there have been court cases, by the way. A good example is the SGR case, where certain confidential information, and Justice Lanola in his judgment then said, I'm sorry, but how can you come over using state information that is privileged and use that to found a cause of action? And the law is very clear. Privileged information without the maker's consent is not permissible. Of course, there are exceptions. For example, if there's serious fraud. But when you're talking about matters of employment or things which really do not even arise as public interest, that's the only limited issue we have a concern with. So we're not saying that any person cannot go to court. Every person is entitled to go to court. Right now, what we've realized, and we've had a conversation with the judges, is that everyone seems to assume that every cause of action is constitutional and you file it in the Constitutional Court. Yet we have so many divisions of the High Court. We have specialized courts. So now what we as the Law Society have decided is we've done our own research, and we've realized when you go to jurisdictions like South Africa, England, and also America, there are filter systems that will assist the public in identifying what is a proper case for this division and this other division. So we will come over, particularly in these guidelines will be on constitutional matters, which will now at least, one, serve to decongest the courts, two, identify the proper cases to go there. We're not saying that we're not barring you. We're only telling you this particular cause of action goes to this particular division, this particular cause of action is ripe for constitutional interpretation.
So the LSK is not fighting.
No,
Okay.
no. It's just exaggerations.
It's exaggeration.
In fact, it's just yesterday, one of these bloggers I will not name came out. I mean, you must have seen it, used some unprintable words against me. I just laughed and I said, surely, why don't you go through the facts?
In the eyes of the public, and I guess we could also use social media as an example, Okiya Omtata is described unofficially as one of the best lawyers in the country. Some say he should be honored by the LSK for the work that he's doing. Would you consider something like that, to have honorary members of the LSK who are doing work on behalf of Kenyans, even though they may not be, don't have passed the bar exam?
Well, I'll tell you, one of the sensitive things that we have about some of our activists is before you consider it for honorary, there's so many criteria you have to look at. And that is something that lawyers have to look at and agree that so-and-so deserves it. So I cannot at this particular stage unilaterally come over and say that Okiya or any other is entitled to that. As I
was going
said,
to ask you your personal opinion.
no, I personally, this particular, let me tell you, once you're in my office, the minute you make a certain personal opinion, the following day you're attacked by 50 people. So you have to be very careful and circumspect about what you think. So now I have to be very careful. But all I can tell you one is this, once we have come up with those particular guidelines, it will assist us in informing the way forward on people we can recognize also. But one thing I must make it very clear, I personally am not attacking Okiya Omtata.
Okay.
All we are saying is we are attacking a system where Okiya or anyone else may not properly use the constitutional process.
Could it be that there are a section of Kenyans that feel that the only way to get justice is through people like Okiya? If we are to buy your theory that they're working on behalf of others, and you said you have proof about that, proxy.
No, you see, the thing is,
litigation.
We're going to now 15,000 advocates in Kenya. 10,000 active, taking out practicing certificates. The others are involved in working for the government, working for other. We have the numbers.
Corporates, etc.
And in fact, there's a lot of public interest litigation that has been that's been going on unnoticed by several law firms in their own individual capacity, by the way. The only thing is we don't publicize. For example, when I took on the case on speed, it was really a public interest litigation, isn't it? I did it pro bono for a client who was caught speeding on Southern Bypass doing 120 kilometers per hour. We went to court. I looked at the charge sheet and I said, I've been waiting for this opportunity for years. So I challenged it before the magistrate and said, this charge sheet is unconstitutional because the penalty, first of all, there's no penalty because the law prescribes an allowance of 20 kilometers per hour. Number two, and let me tell you one thing that's so funny. From 1975 to the time I went to court in 2016, the maximum penalty I told the court was 500 shillings. But do you know what? Over the years, you find Kenyans been, you find 40,000 shillings for exceeding the speed limit by 5 kilometers, 20, whatever. So when we went to the High Court and we won, wasn't that public interest litigation? That's just but an example. There is a lot of public interest litigation that has been happening by lawyers that goes unheralded. Now, one of the things to tell you that we want, arising out of that case, and that has been my personal conviction, I had a meeting with my counsel in the DPP about a month or so ago. We agreed to set up a task force. Now, what is the task force going to do? These charges, like the one on speed, there's several other charges which you call duplex charges. Duplex meaning that this charge sheet contains certain provisions that are unconstitutional. Like, for example, you're exposed to a penalty greater than the maximum prescribed by law. The Constitution says you shall not be exposed to a penalty greater. A good example, and I've done so many of those cases, about 5 or 6 others, and I've won in this sense, particularly starting with City Hall. You find a shopkeeper charged with having an expired item. In fact, one time I remember seeing one club dragging a case for a few years because they were caught with one and an expired tea bag. The cash bail was 50,000 shillings. The case was dragging on for 3 years. A tea bag.
Over a matter of a tea bag.
Yet when you look at the charge sheet, the fine there is 500,000. Would you believe it? So what we've decided is, and the DPP has agreed, that we're going to review all those standard charge sheets in the country, and then we will now streamline them with a proper penalty.
Okay.
Because in most of those penalties, they're usually about 500 to 2,000 shillings because they're misdemeanors. And the penalties fall under regulations, not the substantive act.
Fair enough.
So now that is going to be a profound positive effect for the ordinary Mwananchi in Kenya.
Okay. I want to interrupt you because I also wanted to get your view on the current state of the judiciary.
Yes.
One of your members, actually the former CEO of LSK, Apollo Mboya, he's come out quite recently, talked a little bit about a meeting, a retreat that magistrates had that was partly sponsored, or at least said to have been sponsored by Kenya Power. When you hear of incidents like this, where members of the judiciary are seen with a person or the other that could potentially have a case before them, as the chairperson, as the president of the LSK,
yes,
isn't that something you'd want to speak about?
But let me ask you,
let me ask you
one thing. And this still goes back to the issue of presumption of innocence. There are allegations against Kenya Power, right? Kenya Power is a corporate body. The complaints are against a few individuals. Now, are you going to condemn everyone? Like now, for example, you say a particular community is notorious for certain action. Will you condemn the entire country? No.
At what
my point is, if Kenya Power had sponsored that, and probably that's something that had been in the pipeline for a long time, I don't think that will be sufficient prejudice to affect the magistrates in carrying out or discharging the duties. I don't think so.
So for you, do you think the judiciary needs to do, or what measures should the judiciary, maybe that's how I should phrase this question, should the judiciary put in place to ensure that they are seen as above board? Because I think this one was a perception issue where many would say, listen, these people might have a case before them in court, and true to what that case came to be, and yet you've met with them. Payments have been made to sponsor whatever function you had.
Yes.
Don't you think there's an image issue there?
No, I don't think so. I mean, I think it's been just it's just blown out of proportion. Look at it this way. Where is that case in the first place? It's in the High Court, isn't it?
That's right.
And who was the Kenya Power was sponsoring who? The magistrates. All right. Whether it's the magistrates in the High Court, it's just a sponsor. It's a corporate event.
What then happens?
And let me tell you. Let me finish that.
Go ahead.
The judiciary cannot be swayed by perception. It's not supposed to be swayed by perception. At times, you may find, for example, like the issue of the bail, where one of the magistrates said, based on social media, this is public interest, and then it affected, it clouded his judgment. That's what many of us thought about. But the point is, it's an individual thing. I don't think that for one instance, sponsorship of an event is meant to cloud your judgment, because you're supposed to be dispassionate in coming up to any decision before you.
What happens then when you have a case before a magistrate? On one hand is Kenya Power, and on the other hand is Mr. X or Company X. Can't Company X then say, listen, I'm not sure I'm going to get a fair trial in this matter because I know that a month ago, this same group were at a retreat with magistrates from this particular court as well? How then does that work?
No, you see, we have very strict laws on recusal of a judicial officer. If you can actually demonstrate open bias because of a certain event,
so you have to demonstrate open bias.
You have to, because this is what you're talking about, open bias. Now, beyond that, what bias is it just because I had a few tipples or I had a few snacks and it was paid by a particular individual? Is that food that has been digested after 24 hours going to have an impact on me? No. Well,
and I say this because for journalists, if I'm doing a story about someone and you see me having lunch with them the other day, you're going to ask questions. Now, you know,
this is why
maybe I'm using my industry as a parallel to yours.
Mauro, you're right in this sense. Look at the distinctions. One, we have a corporate institution. Two, we have an individual. Now, if, for example, on the other hand, you're seen having lunch with me as a judge, that is bias. That is a potential bias, and yet there's a case that is pending before me.
Yes,
that's obvious. But we're talking about a corporate institution, so let's draw the distinction very clearly.
Individual versus corporate.
If it's individual, that is definitely open bias. You should not be seen discussing or be seen in public. You see, the perception will be you're probably discussing issues. At times, for example, and that's why being a judicial officer is at times a thankless task. The minute you become a judge, I remember one time my former boss, when he became a judge, spent 1 week and told me, no, I've just gone around to say goodbye to my friends because now I cannot be seen in social places where I used to visit because of the perception. That's the whole thing. And that's why it's a lonely task, and we really have to applaud the judiciary. It's a lot of self-sacrifice. Okay. So now for us to come over and tell them, oh, simply because a corporate institution did that, and in any event, let me ask you one thing. Don't you even have an appeal process? If, for example, you can demonstrate that bias, has anyone actually raised it? let's raise it, let's have it tested in court. But let's not use the public opinion to condemn individual officers.
Fair enough.
Yeah.
I know that we are pressed for time. I do need to let you go. Let me read a couple of questions
Don't worry,
that Kenyans.
I've made arrangements.
You've made arrangements. Fair
Yes.
enough. Let me ask you a couple of questions. The first one is comment from Eldred is asking you, can the LSK president comment on the demand by a Kericho-based hotel for marriage certificates before admission of couples or partners? Should Kenyans be undergoing such scrutiny at public places in a free world?
Now, that's a good point, because just the other day I just came across an instance involving that Sunshine Hotel.
Yes.
And I inquired, what exactly happened? Now, you see, the thing is, you have to get the facts right. Now, from what I was informed, is that the booking was made under, say, XY, but the different people turned up. Now, there's one very important thing that Kenyans should appreciate. You're not required to give a public a marriage certificate, but you are required to give a form of identification. It is the law.
Okay.
Now, when I was in Mombasa the other day on a official function, and I was talking to the general manager of the hotel, and told me one incident that happened in Nakuru. A couple entered the room. The lady did not give a copy of her ID. An altercation took place at night, and the man was murdered. So when the police came and asked, where's the copy of the ID, because you're required by law to keep a copy of the identification details of the person, they didn't have it. The hotel managers locked in for 2 years. So what the hotels rightfully and lawfully are required to do is identification, not a marriage certificate.
Okay.
We are not in Dubai where they'll demand a marriage certificate.
So whatever. So from a law perspective, that hotel will probably have a very hard time proving that they were right.
Now, first of all, have you had
this matter might go to court.
Let's say the thing is, you have to really listen to both sides. What is the true circumstance? Did the hotel actually ask for a marriage certificate or a national ID? Let's determine that first before jumping to conclusions. And that's the danger we have in Kenya. We jump to conclusions without interrogating the facts and listening to both sides. As a lawyer, I'm trained to interrogate both, and I will not condemn a person in hard until I've heard the other side of the story. Now, that's what has been happening for years.
Okay. Let me read one or two other SMSs here. John says, I agree with the LSK boss. Arresting citizens who have not yet been found guilty in a brutal manner is not a sign of a civilized society. Okay. Let me see. Peter from Mary is asking you, hello, an integrity question.
Yes.
Is it right for an MCA, an MP, a senator in full-time employment in the assembly to also practice as a lawyer? Isn't this double employment?
Well, one of the things is the definition of a state officer. And does it bar you from practicing? We have had many colleagues who are MPs. You see, an MP is you're a servant of the people. At the same time, you also have a practice to run. For so long as there's not conflict, I don't see anything wrong with you carrying on your business as usual. Where does it say in the Constitution that the minute you are employed as an MP, you must stop? If, for example, I become a judge, then I have to leave my practice. That's different. Or a magistrate. I cannot serve that because I dispense justice. I cannot be appearing before the same court that I'm sitting in.
Okay. Let me see one more here. It says, Maura, kindly request for a clear picture on balance of weights on defense, offense, and oversight systems and the pursuit of justice. How does the law defend integrity? Well,
it's very simple. First of all, we have very good laws on the issue of integrity. We've got starting with Chapter 6. Right now, as we speak, there is actually an advisory opinion in the Supreme Court. You must have read about it in the papers this week, where the Kenya Human Rights Commission, represented by one of our members, one of the law firms, went to court to seek clarification on, is it right if you're a public officer and you're facing integrity issues that you should continue serving in that office? That is actually an advisory opinion. And the interesting thing is, Okiya Mtata went to oppose and said, you can't proceed this way because there are pending cases in court.
It actually related to a question I had. Should persons who have been charged in court over corruption charges be barred from holding public office?
Ideally,
or even running?
Ideally, the proper systems should step aside until that case is heard and determined. And that's, remember what happened before when former CSs were charged and they had to step aside. You can't continue running.
The list of shame.
Exactly.
EACC list of shame.
It is just proper that you have to step aside until the case is determined, or even resign. I mean, in the West, state officials will resign because of something small. But here, I mean, we've got a thick skin. We'll say, no, I'm not resigning. If, for example, the integrity issue is so profound that it is so clear, and you insist, and then what do you do? The common Kenyan thing to do, you rush back to the community and say, I'm under attack. So since when does the community come over? When does ethnicity override Chapter 6 and integrity? It's wrong. If you are facing serious allegations of corruption, either step aside or resign.
Within the next 1 year and a couple of months or so, when your term comes to an end, and I was very surprised to find out that the term for an LSK president is quite short as compared to the terms of a national president.
Yes.
As Kenya grapples to find its space in terms of development, vis-a-vis corruption and politics,
yes,
what do you want the LSK to stand out for? Okay,
very good. In fact, when you asked me, 2 years is... I was asked that question, by the way, several times. Alan, you've set out to achieve, will you be able to achieve your manifesto within 2 years? I laughed and I said, listen, I'm not a one-man show. I have a community of advocates of over 10,000. And all as a leader I have to do is to reach out to my members to assist in the transformation. So what I have is directional and focused leadership. Now, you'll be surprised that I came up with a manifesto setting out my agenda for the next 2 years. And with my council, we had a similar manifesto in so many ways. As far as I am concerned, I have actually fulfilled over 75% of my manifesto within 100 days.
You could almost resign tomorrow if because many leaders don't achieve that in 5 years.
What we have done is simply this. We have set in motion transformational ways. First of all, to assist the country. Before even becoming LSK president, I petitioned Parliament on 2 crucial bills. Fraud Act. Because you asked, what are we doing about the fight against corruption? Now, the biggest corruption takes place in companies and directors hiding behind the shield of the company. So in November last year, I proposed to Parliament that we need to come up with a fraud act that will actually find those directors criminally culpable. Right now, as you speak, when you look at the penal code, it's not strong on that. So I did my research and looked at the fraud act of England, Hong Kong, and other jurisdictions, and recommended that we really need a fraud act. That I appeared before the committee, they liked it, they took it to Kenya law reform, which is making recommendations. 3 weeks ago, I appeared before Parliament, and this is now on the issue of interest. Right now, it's only banks that are condemned to the induplam rule, meaning you can't charge double the principal amount. Then I posed the question, what about situations where you have Shylocks who charge you 15 to 20% interest per month? Is it right that a Kenyan who's borrowed 100,000 shillings ends up paying a loan of 2 million shillings and then his property is repossessed? It's wrong. So I did my research also and found that in other jurisdictions, induplam applies across the board, particularly in South Africa. They've got the National Credit Act. So the Finance Act is looking at it, and I pray that they adopt my recommendations and change the Consumer Protection Act to ensure that Kenyans are no longer going to be fleeced in those instances. Because it's not fair for banks to have induplam, and yet, Maura, I come over to you and say, Maura, you come to me desperate and say, I want 50,000 shillings. Then 3 months later, I say, I want 500,000. I mean, that's unjust. It's too serious.
It is unfair.
Yeah. So there's a lot going on.
I want to get in one last question to you. Yes. The last time I hosted you here, you were fresh out the election and you had won and it was, in a sense, looking forward.
Yes.
At that time, the biggest issue was the obeying of court orders by government officials.
Yes.
I want to understand from you whether within the time you've been in office, you have had time to think about that and engage government on that, because it was a very divisive issue at that time and it still is right now.
Yes, I have. In fact, in early May, I spoke to the Chief Justice. I have written to him because he's the chairman of the National Council on Administration of Justice. Okay. Now, the National Council brings about the Chief Justice, the executive, civil society, and the legislature. And I brought out 2 issues for discussion as a matter of priority. One, the issue of disobedience of court orders. I said it's important for us to sit down with the executive and judiciary to agree that court orders must be obeyed. Bila maneno. Number 2, I also talked about court orders where courts issue orders almost in perpetuity, in the sense that you issue an injunction affecting, for example, public interest litigation, infrastructure. That delays for years. What happens?
Development slows down.
Development slows down, number 1. Number 2, the contractor on site charges the government penalties in the billions of shillings. Look at Nakumat Lifestyle. Because of a court order, the construction was stopped. Now, we taxpayers are facing a claim of a few billion shillings because of that. You'll be surprised that under the civil procedure rules, injunctions are supposed to be determined within 90 days. Now, that is one thing I brought out. I said, we can't have a situation of orders being enforced in perpetuity. It's almost perpetuity because beyond 90 days, what are you going to come up with for 2 years?
Yes.
Yeah. So that's why people will not even respect the law and say, why should I go to court if I cannot get instant justice? So one of the things, in fact, if I may add on that, which is important to assist to Kenyans, is also the issue of legal aid. We have a Legal Aid Act. Now, in South Africa, the legal aid is strongly supported by the government. So indigent and vulnerable citizens, refugees, children, get legal aid on clear circumstances because there's funding. Our Legal Aid Act from 2016 to date has not been funded. The budget has been cut from 150 million recently to 50 million.
50 million.
Yeah. So one of the proposals that I thought about, in fact, in the last couple of days, is why not go back to Parliament, seek an amendment to the issue of funding. And the easiest way, in my estimate, is this. Every day, the government collects millions of shillings in fines through traffic offenses, anything. Why don't we then amend the law and say, out of those fines, a certain percentage, say 10 or 15%, automatically goes to fund legal aid. And there you have it. Government, actually, we, the guilty, will fund legal aid. And I think that would be...
You said, how far is that process?
Well, it's a proposal that I want us now to take up.
Okay.
And what I'll say, what I can assure Kenyans now, is as far as the Law Society is concerned, we are going to take action in terms of legal reform. We are going to suggest several changes to the laws that will actually access justice to the Wananchi, improve legal aid, and also at the same time assist the government in achieving its agenda. Because if you don't have a smooth, investor-friendly environment, we're not going to move far.
Alan, thank you so much.
My pleasure.
We're going to be here to keep you accountable. You've made those promises very publicly.
Yes.
We'll have another chat a bit later on this year or early next year. Thank you
very much
for sparing time to be here with us. Thank you for everyone who watched and for those who sent us your messages, a couple of them, just for texting. Let me see. Someone from Nakuru says, unfair dismissal by government agencies. Okay, so they're asking if the society can assist Kenyans who cannot raise legal fees to pursue justice in courts, like cases of unlawful and unfair dismissal by government agencies. There is clear and glaring injustice, but no money to go to court, as all money saved went to a loan incurred during service. This is Vincent Omondi from Nakuru. Another person here says, Kenyans feel cheated and lost in this maze of justice. The rules of engagement between lawyers and client are not clear in terms of payment and charges. It is a high time we have timelines for family cases, and charges should reflect on the average Wananchi so as to improve access to justice for all. Mr. President, you're going to have to come back. The messages that they're really coming in. We don't have time right now. We'll call you in again, and what I can do, maybe I can hand some of these over to you for you to have a think through and see what you can do within your office.